The last clear chance doctrine. Virginia's only defense for cyclists in contributory negligence states in Virginia even a minor cycling mistake, rolling through a stop sign, forgetting a hand signal, or failing to ride far enough to the right, can destroy a personal injury claim. The state remains one of the few jurisdictions to follow pure contributory negligence, so being even 1% at fault allows insurers to deny compensation entirely. To counter this harsh rule, injured cyclists and their attorneys must rely on narrow exceptions. The last clear chance doctrine shifts responsibility back to a motorist who had the final opportunity to avoid a crash but failed to act. A second exception, willful and wanton negligence, applies when a driver's misconduct is so reckless that it overrides the rider's minor fault. The last clear chance rule assumes that both parties were negligent yet focuses on the driver's later conduct. It allows recovery when the motorist could have avoided the collision after the cyclist's misstep and had more than a split second to do so. Courts apply different standards depending on whether the rider was helpless or inattentive. A helpless plaintiff negligently places himself in danger and cannot escape, for example, when a chain snaps or pedal breaks, leaving him stranded. In that situation, the driver is responsible if they saw or should have seen the danger in time to stop. An inattentive plaintiff remains physically able to avoid harm but fails to see it, like a cyclist who glides through a stop sign without seeing an oncoming vehicle. To recover in this case, a lawyer must show that the driver actually saw the cyclist's peril and still chose not to act. In either situation, the crucial issue is whether the driver's opportunity came after the cyclist's negligence and lasted long enough to make avoidance realistic. The doctrine's limits are illustrated by cases where the rider's negligence and the driver's chance to act were simultaneous. Courts have rejected claims when a motorist had only a moment to react, emphasizing that a true last clear chance requires a distinct interval during which the collision could have been prevented. Without such evidence, the contributory negligence rule controls and the cyclist recovers nothing. Virginia law also distinguishes simple negligence, gross negligence, and willful and wanton negligence. The last category describes a conscious disregard for others' safety. If a motorist drives while intoxicated, deliberately buzzes a rider out of road rage, or races through a residential area or school zone at extreme speed, their conduct can excuse a cyclist's minor fault. Unlike last clear chance cases, which generally yield only compensatory damages, willful and wanton negligence may open the door to punitive damages capped at $350,000. Because the injured rider bears the burden of proof, prompt action is essential. Evidence that shows the motorist's final opportunity, witness testimony, surveillance or dash-cam footage, police reports, and professional reconstruction, must be preserved before it disappears. Every day that passes gives insurers more ammunition to argue that the cyclist's 1% mistake bars recovery. A proactive attorney will gather this information quickly and build a narrative that highlights the driver's inattention or recklessness. Jennifer Porter Law, PLLC notes that cyclists do not have to face this legal minefield alone. Jennifer Porter is a seasoned Northern Virginia bicycle accident lawyer and former insurance defense attorney with decades of experience representing severely injured clients. She uses her knowledge of insurance tactics to maximize compensation for cyclists and other accident victims. Through her law firm, she offers rights-driven representation to riders in Virginia, Maryland, and the District of Columbia. Riding a bicycle in Virginia should not mean forfeiting your right to be made whole after a collision. The contributory negligence rule is harsh, yet the last clear chance doctrine and the willful and wanton negligence exception offer a path to justice when a motorist had a real opportunity to avoid harm or acted with reckless disregard. With timely evidence and experienced legal representation, these exceptions can defeat the 1% rule and allow injured cyclists to recover the damages they deserve. Contact the law firm Jennifer Porter Law, PLLC at 571-532-9070. located at 8001 Braddock Road, number 102, Springfield, Virginia, 22151, United States, to discuss your case and protect your rights.